This will be the People News. Okay, not an attorney. Educational purposes only. Do your own research. Okay, never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Use that Second Amendment. Arm yourself with knowledge. All right, let's find out what this man has to say.
Created a security when you're born, and they deposited it into a Treasury direct account and deposited them into a Treasury direct account in conspiracy with wrongdoer Janet Yellen and her predecessors under their minor estate entity, Glenn Winningham Byrne, putting the demandant into bondage and enslaving the demandant as collateral for their minor estate as described in 31 CFR 363.6. And it says entity means any owner of a Treasury direct account that is not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company trust, the estate of a decedent, or the estate of a living person such as an incompetent or a minor. A minor means any individual under the age of 18 years. The term minor is also used to refer to an individual who has attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. So there you go, right there. And that these County of Montague and Bowie Independent School District Mafia are assaulting the demandant to put the demandant under the Commerce Clause, Article 1, Section 8, Clause 3, so they can justify bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17, because none of them have any intention of honoring their oaths of office. All regulations, including 31 CFR 363.6, are for property of the United States, and this is Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. So a slave is owned and therefore property, and a U.S. citizen is a business entity. And this is 102 Stat 1344, Public Law 100-418, August 23rd, 1988. The term United States business means a United States citizen and includes the minor estate, and as further evidence they're using the Commerce Clause to bring the District of Columbia outside not exceeding 10 miles square in violation of Article 1, Section 8, Clause 17. And this is that case, National Mutual Insurance Company versus Tidewater Transfer Company. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington, District of Columbia, and through their plenary power, plenary is dictatorship, nationally covers those citizens, even one of the several states, until the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. The minor estate and the Texas tax code is a bill of pains and penalties, which is similar to a bill of attainder and is unconstitutional. A bill of attainder means a legislative act, no matter what their form, that apply either to named individuals, in my case, Glenn Winningham Byrne in all block capital letters, or to easily ascertainable members of a group, okay, the so-called Patriot Act, okay? There's all of that stuff. It's all bills of attainder. Any person, that's a group, in such a way as to inflict punishment on them without a judicial trial.
Talked about this in a couple of videos back, right? Every case, even criminal, is under the civil, okay? And it's under administrative and not judicial. That's the reason why our alleged judges are administrative magistrates, our judges judicial. But they're all bringing us in under the administrative. And that's the 1947 Administrative Act.
Punishment on them in such a way as without a judicial trial. A bill of attainder, a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, also termed Act of Attainder. That's Black's Law Dictionary, 8th edition.
And in Texas, it's Article 16. And it'll tell you a bill of attainder ex post facto.
A bill of pains and penalties. A bill of pains and penalties, the legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. A bill of attainder is the death sentence. Bill of Pains and penalties are included in the U.S. Constitution's ban on bills of attainder. And so penalties, Bill of Pains and penalties. They call it the Texas Penal Code. Penalties, penal code. That's the same word, only different versions of the same word.
And again, why do you think you always hear in almost every case I heard of, but I'm sure there's cases out there it's not that way, but even in your criminal case, 20 years plus $5,000 fine, 10 years plus $500 fine. Every case has some fine attached to it. Why do you think that is, y'all? It's administrative, and to really bypass the Constitution of the Bill of Attainder. But you're not getting your true due process.
97th District Court might be a superior court of general jurisdiction under some circumstances. A court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. But when a superior court of general jurisdiction undertakes anything that is interrogation of common law, it becomes quad hoc an inferior court of limited jurisdiction. And the Texas Tax Code has absolutely nothing to do with common law. And this is American Jurisprudence, Book 20, Section 103, second edition, Section when therefore a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purposes of such proceeding. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of this jurisdiction does not apply. It is familiar law that when
everything is done by the basis of presumptions. That's the reason why you got to challenge the facts and the law. Okay? What's the other words you want? It was in my brain a second ago. You have a right to know the nature and the cause. They usually have the nature, but they never actually have the cause.
Special statutory authority in derogation of common law is conferred on courts of general jurisdiction. Such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. And these are Alabama court cases. Therefore, it is actually an administrative hearing for the Texas Tax Code. A ministerial act is an act that a public officer is required to perform in a prescribed manner in obedience to the mandate of legal authority and without regard to his own judgment or opinion concerning such acts' propriety or impropriety. When a given state of facts exists, discretion, on the other hand, is a power conferred on public functionaries to act according to the dictates of their own judgment. And that's California appeals case. When acting to enforce a statute and subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administering and enforcing statutes do not act judicially. Then, by definition, that's a bill of attainder. But merely ministerially, but merely acts as an extension, as an agent for the involved agency. So the issue is bring up the issue of the bill of attainder. And in fact, really what you should do is sue them in their private capacity as a collateral attack in the federal courts, and we'll see. I mean, a lot of the courts are very corrupt these days. And so, it's hard to say, what will happen. That's why I'm bringing this action. And I'm telling them, that they intend to murder me. So we'll see what happens. Judges who become involved in enforcement of a mere statute, civil or criminal in nature, and otherwise act as mere clerks of the involved nature. Okay, so mere statutes, all statutes, not just some of them, all of them, which is actually an executive agency working for the executive branch. The word administrative is synonymous with the word executive. The word administrator connotes of or pertains to administration, especially management, as by managing or conducting or superintending the execution, application, or conduct of persons or things. Black's Law Dictionary, 6th edition. Those acts, thus administrative acts, are those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body. It is common to use the two words in tandem, which means Patricia Coleman Byers failed to be a judge for that proceeding, but was actually a bought and paid for clerk masquerading as a judge and cannot do anything judicial. Ministerial officers are incompetent to receive grants of judicial power under the legislature. Their acts and attempting to exercise such power are necessarily nullities, which means it's a bill of pains and penalties in violation of the supreme law of the land, Article 1, Section 9, Clause 3, and Article 10, Clause 1. Because there is no judge as defined by Article 3 of the Constitution, but only an administrator working for the executive branch was there. No bill of attainder or ex post facto law shall be passed. Notwithstanding any state constitution or law, Article 6, Clause 2, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the constitutional laws of any state to the contrary notwithstanding. When the founders were talking about...
There you go. And I believe that would be Marbury versus Madison. Which part of it is really good, what they brought up, but the other part is where they gave themselves authority that they constitutionally did not have.
Bills of attainder in the Constitution and non-judicial trials, they were talking about Article 3 judges, and an executive administrator fails to be an Article 3 judge. And recently, the Supreme Court even said that only an Article 3 judge can do anything affecting life, liberty, or property. And this is 21. So this is U.S. Supreme Court Justice Thomas concurring. Cases involving deprivation or transfer of life, liberty, or property constitute a core of cases that must be resolved by Article 3 courts, which has been previously affirmed on numerous cases. This is Williams versus United States, 1933, where a controversy is such a character as to require the exercise of the judicial power defined by Article 3, jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or, of course, in an executive officer, administrative, or executive board, since they are incapable of receiving it.
And again, why do you think we got to challenge jurisdiction of the courts? Which jurisdiction are you under? Right? Are you under the administrative jurisdiction? Are you under the common law jurisdiction? Are you under the United States of America Republic jurisdiction? Are you under the United States business part of the jurisdiction? There are so many different type of jurisdictions. When you walk in there and you don't challenge the jurisdiction, you're in silence, acquiescence. You tacitly agree to the judge's jurisdiction and the attorney jurisdiction. Why do you think your attorney never challenged jurisdiction? But, you know, the obvious jurisdiction, like from state to another state or state to federal government, you know, the obvious deals that some attorneys do. But when you walk in there, you do not actually know which jurisdiction. You've heard some of these alleged sovereign citizens, right? Amity jurisdiction. There's amity. Whether or not it plays into your case or not, the simple fact is still exists, and it's still a jurisdiction. Are you or are you not brought into amity jurisdiction? Are you not brought into martial law under the Civil War Act that's never ended? Okay, So there's several jurisdictions. There's a reason why you got to challenge jurisdictions, right? Then you got the jurisdiction, personal jurisdiction, and subject matter jurisdiction. And then on your property tax, it's AMRAM jurisdiction, but that's for banks or loans or contracts and all that kind of stuff. But does your county actually hold the title to your property to have you in AMRAM jurisdiction? They can't even tell you why you're in that court, right? They say you'll sit there. Well, you brought in here under a debt. Judge will tell you it's not a debt, but he would never tell you what you are under. What jurisdiction are you under then? All right? Due to my research, I am led to believe and do believe that they put it under obligations. Even though they keep telling everybody from a distance, it's volunteering. Taxes are volunteering. They keep saying it, but it's volunteering under the threat of arms or theft of property taken from you. If you don't do these things, we're going to steal from you, or we're going to come and kidnap you, and all these things. Everything's done by threats. So you got these three different things, right? They're going to come and get you for a debt. You go to court. You didn't pay your taxes. Well, it's because they say it's a debt. And then the judge tells you it's not a debt. So, but he won't tell you what it is. So it's under the obligations. Or they wouldn't have any power. Or, that you just jumped in there and say, hey, I'm a taxpayer. You volunteered. Quit going in there and saying you're a taxpayer.
To me, that statutes that would deprive a citizen of right of personal property without a regular trial according to the course and usage of common law would not be the law of the land. And the Montague County Sheriff, under instructions from the County of Montague Mafia, was notified. Has notified the demandant they're selling the demandant's land to satisfy their common law tax lien.
Anyways, like he says, videos went long enough. Here's a little taste, okay? This will be the People News. Bye, y'all.